Hi there, welcome back to Intercorp Legal English. I'm Jade and I'm here to walk you through the world of legal English, especially the kind that shows up in business contracts but rarely gets explained. Today, I want to talk about something that often gets ignored in contracts, not because it's unimportant, but because it doesn't look exciting. I'm talking about boilerplate clauses. Sounds strange, right? You have probably seen them. They are usually tucked away near the end of the contract. The part that say things like governing law, jurisdiction, entire agreement, and so on. They sound repetitive, overly formal, and for many people, they feel like just another formality, but in reality, they are anything but. Boilerplate clauses are the legal backbone of your contract. They don't explain what you are buying, selling, or delivering, but they design what happens when something unexpected occurs, and more importantly, they define the rules of the game if a dispute arises. Now, let's take a few examples. Governing law tells you which country's legal system applies. You may be signing a deal in Vietnam, but the clause quietly points to English law or Singaporean law. If things go wrong, that one sentence could mean you are resolving disputes under a legal system that you have never studied in a language you don't use every day. Then there's jurisdiction, which says where you go to court. That may be the same place as the governing law or not. This could require you to bring a claim in Hong Kong even if the work was done in Hanoi. Another is the entire agreement clause. This one says that the contract in front of you is the full and final understanding. Anything discussed before unless written down in the contract doesn't count, which means that verbal promises, emails, or even signed letters could become legally irrelevant. That's a big deal if someone relies on what was said outside of the official document. One more worth mentioning is the force majeure, a clause that excuses parties from performing the contract when something extraordinary or uncontrollable happens, like a natural disaster, war, or a pandemic. This became especially relevant during the COVID-19, but the actual protection depends heavily on how the clause is drafted. Not all force majeure clauses are created equal. And finally, the severability clause. That's the one that saves the rest of your contract. If one part is declared unenforceable or invalid, it ensures the entire agreement doesn't collapse just because one clause goes back. Now, why does this matter to you, especially if you are not a lawyer? Because these clauses may sound like technicality or formalities, but they carry real legal consequences. I have seen many cases where people lost time, money, and rights simply because they didn't pay attention to what was hiding in the boilerplate clauses. As the legal practitioner, I have also seen how a small mistake in wording, especially between languages, can shift the meaning of a clause completely. So even if you are using a bilingual contract, don't assume both sides say the same thing. Check carefully, and when in doubt, ask questions. Boilerplate is not the place for guesswork. So to wrap up, don't treat boilerplate clauses as background noise. They are not just the usual stuff. They are often the clauses that speak the loudest when things go wrong. Read them, understand them, and where possible, localize them to your context. That's it for today. I'm Jade and thank you for listening, and I will catch you in the next episode where we will unpack more legal English in plain and human language. And remember, in contracts, the stuff you skip may be the stuff that's cost you.